Welcome to SST College of Arts and Commerce. This is SST Edupedia. Myself, Assistant Professor Sunil Shah. Today I would be covering up the topic called comparison of partnership, LLP and the company, which is there in the subject called business law under the class of SYBAF semester 4, and the topic which is there in unit 2. Coming to the very important part of comparison of partnership, company and LLP, the law which is prevailing under the partnership is Indian Partnership Act 1932 and the rules made thereunder. Under the company is governed under the Companies Act 2013 and LLP is governed under the LLP Act 2008 and the various rules made thereunder with the amendments read to be. Registration, the partnership, the registration is optional, whereas in company the registration is compulsory as well as mandatory. Registration has to be done with ROC. The LLP, the registration is compulsory and the registration has to be done with the register of LLP under the state where the LLP is to be registered. The partnership, as you are aware, the one partner is the agent of the other partner. It has been created by the contract. The law which is governed is under Indian Contract Act 1872. The company has been created by law with the statutory act of the parliament, and the LLP is also been created by the law. Coming to the next important aspect related to the comparative points of the Indian Partnership Act, LLP and the partnership, distinct entity. Partnership is not a separate legal entity, whereas the company is a separate legal entity as discussed under the Indian Companies Act 1956. LLP is also a separate legal entity which is discussed under the LLP Act 2008. The name of entity under the partnership, the name can be done as per the choice. So it is no such fixed rules. Whatever the name, what the partners feels like, they can put the name for the partnership. In case of company, the name to contain limited in case of public limited company, and in case of private limited company, the word should be added with private limited in the suffix. In case of LLP, the and name of that particular firm should be with LLP word should be there. So that name of that LLP firm should be ending with the word LLP. Perpetual succession, as you are aware, when all the partners expires or when there is a dissolution of the firm, the firm doesn't comes into existence. It has been dissolved forever. So it does not have a perpetual succession. It depends upon the will of the partners, because the partnership has been made as per the will of the Partnership Act, as per the deed which has been formed. Whereas in case of company has a perpetual succession and members may come and go. So whenever the members are retiring or the members are been giving that particular resignation, still the company would be in existence until the company goes into voluntary dissolution or the voluntary winding up, or with the winding up with the orders of the court. Whereas in case of LLP, the law which is prevailing, it is also has a perpetual succession as the partners may come and go. Under the Partnership Act, we would be calling as partners. Under the company, we would be calling as members, whereas in LLP, would be calling as partners. The word LLP is limited liability partnership, so the persons who are there in LLP would be calling as partners. In case of company, would be calling as members, whereas in case of partnership, would be calling as partners. Related to the main document, the charter of the document, partnership deed, the content which has been mentioned in the partnership deed is called the charter document, or the main document, the heart of that particular constitution of the partnership firm, which denotes the scope of operation, the rights and duties and the liabilities of the partnership depends upon the partnership deed. Company, in case of company, the memorandum of association and the article of association is called the charter of the company, and it defines the scope of its members. Whereas LLP Act is in case of LLP, the act which is governing is 2008 LLP Act. The LLP agreement decides the charter of the rules, regulations of the members, and its scopes defines about the operation, rights and duties of the partners vis-a-vis LLP. Regarding the common seal, there is no concept of common seal in case of partnership, whereas in case of company there is a concept of common seal, and every company shall have its own common seal. Whereas in case of LLP, it denotes the signature, and the LLP may have its own common seal, it depending upon the terms and conditions of the agreement. Format is for incorporation along with the form. which has been issued by the register of firms, they have to file an affidavit by each and every partner his intention to become the partner, and he has to required to file with the ROF, that is register of firms, along with the requested amount of the fees. In case of company, various e-forms, since we are into the digital era, the formation, incorporation of the company is also digitalized, so that all the e-forms has to be uploaded with the supporting documents along with MOA and AOA, and has to be filed with ROC, that is register of companies, with the prescribed fees. Whereas in case of LLP, also we are into digital era, various e-forms has to be uploaded along with the affidavits and has to be filed with the register of LLP. Here in case of partnership, it is with register of firms. In case of company, it is with ROC, that is called register of companies, whereas in case of LLP, with the register of LLP, with the prescribed fees as mentioned under the Act. Legal proceedings, if you speak about the partnership, only registered partner can sue the third party. So, as we had discussed in the earlier slide, the partnership registration is optional, but if you register, then you can sue the other partners in case of fraud or misconduct or any related to accounting system of the partnership. You can sue only and only until and unless the partnership agreement is been registered. Whereas a company, it is a legal entity which can sue and can be sued. Sue means you can file a case, and sued means the company can file its case on its own name. So, the legal proceedings, the suing part, whereas the company can sue in its own name and can be sued, that means other persons can file the case in the name of the company. LLP is a legal entity and can be sued and can be sued. So, these two common are the characters in case of LLP and the company. Regarding the foreign participation, foreign nationals cannot form a partnership in India. This has been banned. Whereas company, foreign national can be member of in a company, but you have to appoint, you have to get an approval from RBI. Whereas in case of LLP, foreign national can be a partner member in an LLP after taking the approvals from ROCs and RBI. The number of members in case of partnership is 2 and maximum 20. In case of company is 2 to 50. In case of private limited company, minimum 7. In case of public limited company, and maximum is unlimited, as we all know. In case of LLP, the minimum number of partners are 2 and the maximum, there is no such limit. We can have n number of partners in case of LLP. Coming to the ownership of the asset, a partnership have a joint ownership of all the assets belonging to the partnership firm. So, the asset belongs to the partnership firm. The company is independent of the member of ownership of the asset, so that all the asset belongs to that particular company, not the members of the company, not the directors are having their own asset. So, once the company has been incorporated, all the asset belongs to the company. In case of LLP, is an independent of the partners, has the ownership of the asset, so that the LLP's asset would be declared. So, no other partner can claim that the property is what he has brought during the LLP formation is own. Once it has been incorporated, it is an property of LLP. Rights, duties, obligation of the partners and the managing partners of the or the directors. Right, duties and the obligation of the partners are governed by the partnership deed. In case of companies, the right and duties and the obligation of the directors and are governed by article of association and resolution passed by the shareholder during the AGM or extraordinary meeting. The rights and duties and the obligation of the partners are governed by LLP agreement. Coming to the liability part of the partners or the members of the partnership, company and LLP. As you are aware, partnership is an act which has been governed by the Indian Partnership Act. The liability is unlimited. Partners are severally and jointly liable for the actions of the partners for the firm, and liability extend to the personal asset. If there is a fraud or misconduct, then the personal asset would be also attached, which is the law under the Indian Partnership Act. In case of company, general liability to the amount of the unpaid share capital or the amount of share paid capital would be evolved. In case of LLP, there is a limited liability, as the word which has been derived from limited liability partnership. The liability is limited for the extent of the contribution towards the LLP, except in case of intentional fraud, for the wrongful act or the omission or commission of the partner. So, the main advantage of the company formation and LLP is that related to the liability is very limited to the cases where there is intentional fraud. When there is a fraud which has been committed by the partners of the LLP which is done intentionally, then that only that particular partner would be liable, not all the partners would be liable. And if you are speaking about the wrongful act or the commission or the omission by the partners, if the partners are acting with the due diligence or acting with the reasonable care, then that particular partner won't be liable. Then those partners who had done this particular commission of the act or the omission, he would be only liable and the other partners won't be liable. Coming to the principal agent relationship, the partners are the agent of the firm and of the other partner. That is the relationship. In case of company, director acts as the agent of the company and not of the members. Whereas in case of LLP, the partners are acting as the LLP agents of the LLP and not of the other partners. Dissolution, you are aware that by the agreement or by the mutual consent or insolvency or on happening of the certain contingency, the partnership would be dissolved. Whereas in company, there is a voluntary winding up or with the compulsory winding up by the order of the court or by the National Company Law Tribunal, then only the company would be winding up. Whereas in LLP, there is a voluntary or by the order of National Company Law Tribunal, the LLP would be winded up. So if you speak about the dissolution part or the winding up, dissolution word is used normally in the case of partnership, whereas in case of company, winding up word would be used, whereas in case of LLP also the winding up word would be used. Coming to the whistleblowing part, this is something unique. No such provisions are made under the Indian Partnership Act, whereas in Companies Act there is also no such provision related to the whistleblowing. If you speak about the LLP, provision has been made to provide the protection of the employees and the partners, providing useful information during the investigation process or convicting of any of the partner. So under the whistleblower, whoever informs to the ROC or the register of the LLP there is some misact of the partner which would be harmful to the each and every partners or the peoples at large, whoever informs, he would be protected by the government. So this particular policy of whistleblowing would be only applicable in case of LLP, whereas in case of partnership and in case of Companies Act it is not applicable. Thank you from my side. This was in short related to the comparison of partnership, company and LLP. Thank you.